Thank you. So I was charged with the legal implication of use of military robots. And as my previous speakers said, starting with EU law to discern some workable conclusions on that is not working. So as I'm coming from IHL, International Humanitarian Law background, I decided to go into international law and see how this source of law, which is a primary source for EU, but also all member states, is playing with the use of military robots. So in my presentation, I will start with something that lawyers love, and we are for sure lacking in the area of new technologies, means definitions. So we know what we are talking about. Then the procedure that I already somehow announced this morning, legal review, the procedure that nobody knows what it is, and that's why it's ignored. Then, as Zvonko rightly pointed, the biggest problem with drones, military robots, is not their mere nature, but the way they are used, so the method. And we already have seen that with 20 plus years of drone warfare, especially done by US, but also France, and now Ukraine, where legal risk is for states. Then shortly about responsibility regimes and to the conclusions. So starting with definitions. We have military robots, unmanned platforms, depending on the domain. You can add aerial, ground, water. Weapon systems and drones. I will use them interchangeably. Of course, drones are the fastest and the shortest to be used. But of course, those are not legal terms. We have no definition even of the word weapon in international law. Of course, it doesn't stop states from regulating weapons without defining them. So what we find in international treaties are two words that are frequently used, especially in Geneva Conventions and additional protocols to that: means of warfare and methods of warfare. So if we talk about drones, or cyber weapons or chemical weapons, we are talking about means of warfare, meaning objects that we use to increase our force. But when we are talking about bombing, aerial bombing, targeted killings, we talk about method, the way in which one object can be used. And those are especially the methods that I will be focusing today on. So the second difference that Zvonko also announced is between remotely piloted platforms and autonomous platforms, weapon systems, whatever. So because in our common work we have also a chapter on AI, we decided that we're not going to focus on autonomous weapons in the chapter part. That's why I also focus only on the remotely piloted systems, because from legal and ethical point of view, the challenges are very different. As we heard yesterday about AI, there are many ethical questions that can be translated into legal considerations. But for remotely piloted systems, we have one difference. There is always a human operator, because if it was like AI operator, then we would say that this is autonomous. So we always have a human being to blame for errors and bring to responsibility. And actually, from legal point of view, this is very important. And that's why the mere nature of drones, because of the fact that this is another weapon that is being used, another platform being used just to enlarge the reach of the military, because we don't have to move to a specific continent, we can just send there the platform, it's not that problematic. And speaking about this human control, we also have seen in Geneva and further discussions, three not legal terms, but which are very widely used: human in the loop, on and out of the loop. Loop here is for the decision-making process. So drones are where human is in the loop, because it is a human that pushes the trigger that starts the reaction that is precisely planned. On the loop would be when human is supervising what is happening and can intervene. But it's really hard to discern that from human outside of the loop when the AI is there, because we say that if you have to monitor 20 drones that are operating simultaneously, what is your reaction time? What is your reaction ability? So, but this is all to the autonomous part, so human in the loop here. So, I already said that there is no targeted regulation of drones, military robots. But it doesn't mean that international law is not prepared for technological development. As soon as in 1977, states decided to include Article 36 in the additional protocol to Geneva Convention, the one that relates to international armed conflicts, so between states, which, as you can see, is saying that each state, when it studies, so research and development, acquire or adapt, so buy, purchase, lease, whatever mode of acquisition is applied, a new weapon, mean, or method of warfare. This is somehow inconsistent, but let's ignore that there is new weapon and mean of warfare in the same phrase. But so each state has to check whether employment of that weapon in all or some circumstances, situations, can be prohibited by international law. And it's all type of international law. So stemming from that one provision, that is not, this is all. There is no more detail. So we don't have a specific procedure. States are not obliged to implement a specific 1 to 10 steps to do that. There is a free possibility for them to shape it, to tailor it to the national law, to the needs, etc. But ladies and gentlemen, what is the problem? So there are 174 state parties to that treaty. Of course, US is not party, and Israel is not the party. Well, but all EU member states are parties to that treaty. So we are all legally obliged to conduct that kind of review. And then, since I done my studies 10 years ago about drones, when Polish government decided to buy armed drones that are just now being bought, so you see that also the decision-making time is pretty long. So out of my research, it seems that globally, only 20 states are conducting that review, including US and Israel, which are not legally obliged under international law to do so, but only 12 of them are from EU. And here you have a list, and I would say that from our interest, the states that are in the center of our interest, only Czech Republic is doing that. That's why I asked also before whether Hungary is doing that. And other are rather Scandinavian and Western European countries. And what is the problem with that procedure, that there is no one way to do it? And also states are not obliged to publicly acknowledge, to publish the results, to speak out about it. But of course, as citizens, you can ask your government whether they have this, and they can give you an answer or try not to give you an answer. But out of the best practices that are being implemented, and I think that this is very important because for each new technology, new weapon, it's going to be relevant, it is recommended that this procedure is multidisciplinary, especially with complex technologies like AI, where we need more experts to see what are the consequences of the use of such a weapon in a specific situation. And also it should be a continuous due diligence. Imagine that we have AI that is being, the software is being updated, so it changes the specifics of the weapon, so there should be a new risk assessment. So the procedure should be tailored to the specific weapon, the subject of the analysis. And from best practices, it seems that it should include not only expert technicians, but also doctors that would be able to say what kind of injury and harm can be inputted on people with that weapon. IT people probably for advanced weapons, military people, lawyers, and maybe ethicists. There is no possibility of transfer of certificate of compliance. So if Poland is buying a weapon from US, it has to do its own legal review. Why? Because first of all, this weapon is new to Poland, and secondly, more importantly, we have different legal obligations. US is not party to European Convention of Human Rights, but Poland is. And we have already seen in our history how many times partner countries within NATO are succumbing to legal responsibility for actions of our partners. I will come to that in a second. And as I said, results don't have to be public. Of course, it would be nice to have them in some way, to have them published in general parts at least for more transparency, but also they don't have to be binding. The states that are implementing that procedure have very different modalities of those procedures, but none of them is that saying that the final report of the study is binding upon political leaders that are deciding to buy specific weapon. So for legality, how much time do I have? Because maybe, okay, half of time. Okay, so as I said, sometimes in international law we can find weapons that are specifically prohibited per se, like nuclear weapons, chemical weapons. We have nothing like that about robotics. But it doesn't mean that there are no legal rules that apply to them. When we use them, we have to interpret general principles of law, general rules, and in case of military robots, the global war on terror, which is not a legal term, because that would be armed conflict, and it's hard to imagine a global armed conflict nowadays, but well, so this 20 years of experience showed us that, first of all, with use of military robot, we can violate some basic principles enshrined in a UN Charter, like prohibition of the use of force that can, of course, can be classified as aggression, as well as in case of Russia. We can imagine that by trespassing aerial space of another state without its consent, the state using that drone is committing aggression, because a drone is a part of armed forces of that state, and of course entering airspace is violating territorial integrity. We have also seen in Pakistan that drones hovering over a country can really have an impact on internal politics. It can influence the political independence of the state. And this use of force, of course, can be justified in two exceptions. When UN Security Council is saying that it's okay to go with that force to another state, or when you use self-defense. So, of course, the drone warfare showed us that self-defense is becoming a bigger term than it was supposed to be. So we see states saying, oh, we will use anticipatory self-defense. They still haven't attacked us, but we think they're gonna do that, so we will send a drone. There are also some, at the beginning, especially in US, there was a national provision saying that a president can cannot send troops outside of the state without approval of Congress. But when you are sending a military robot, it's not a troop, right? Of course, then it was changed, but this shows how different small provisions can be changed just because of the fact that they are unmanned. Then there is international humanitarian law, so the conduct in armed conflict, and what Zvonko said about the problems of, well, you actually didn't say that in presentation, but in chapter it is being discussed, the precision myth. Yeah, they should be precise. They are more and more precise, but they are not very precise as they are being publicized. So we have a problem of distinction, proportionality, and precautions that are being taken into attack. Those are the general rules of targeting that are applicable to all types of attacks in armed conflict. And the amount of collateral damage, it means unintended damages in civilian population and civilian objects, was huge with the use of drones, and actually it was a source of protests from local communities that were subject to that kind of attacks by mainly American drones. And of course, in international law, in international armed conflict, we have a much more robust regulation of rules of conduct. But in non-international armed conflict, when this is a conflict between government and armed groups, or between armed groups, think about Syria, we have many more provisions coming from human rights law. And of course, human rights law has this more robust than in international humanitarian law protection of right to life. So when a state is engaged in non-international armed conflict and is using lethal force, it has to meet higher standard of precision and necessity of attack. Some people are claiming that in non-international armed conflicts, states should rather capture than kill. So then, of course, there was a question, how can you capture with a drone? But as we have seen in Ukraine recently, there were successful moments when a drone, armed drone, threatened a Russian soldier that if he doesn't surrender, he will be shot. So the soldier dropped the gun and was escorted by a drone to the nearest Ukrainian unit. So there are ways to circumvent that. But of course, now coming back to our European perspective, we are all members to European Convention, so we are subject to the jurisdiction of Strasbourg Court. And we have seen already cases when European countries were sued in front of that court by families of victims. And this is a specific legal risk, I would say, that we have to take into account when we are planning our warfare. So two methods that were developed with drones is targeted killings. Of course, targeted killings was not developed with drones. It means it's a specific operation on a specific target. You know, killing Osama bin Laden was a targeted killing. Before it was done with special forces, now it can be done with a drone. But more contentious method was signature strikes. Did you ever hear about that? Yeah, I see. So it's not that you have a very identified object, but you have some number of characteristics that would somehow identify a target. Let me tell you that some of them are, for example, people around a training camp. It was especially developed within the war on terror. So people involved in training camps for terrorist groups. People who are around that, not that are especially having a combat function. So, well, the details of that method can be read in, yes, my book, my chapter book. So. A book chapter. So I invite you to see that. So what are the other problems? US showed us that CIA can operate drones. And if it's done within armed conflict, it is illegal because CIA is civilian agency and weapons should be operated by armed forces. So this is one of the problems. Then who is the target? How do we identify the target? Here we add the layer of AI, supportive decision-making like this Palantir or Gospel and other similar systems. And then the biggest problem, when and where the attack is taking place, because with drones we can reach every part of the world, and it means really that we are starting wars everywhere, and especially when our citizens are not being directly endangered by that war, but we are doing a proxy war somewhere else with the remote system. So here, one thing, when it comes to legal responsibility for the operator of a drone, there are no new challenges. It's the same as with the sniper. But for state responsibility, we have an objective regime that is saying that it is enough to attribute a wrongful act to a state, and this is also nothing new. But we as European states, we can be also held responsible for complicity. So if we are cooperating in a military mission and we are sharing intelligence, we are providing logistical support or technological, we can be sued. Think about Ramstein Air Base, US base in Germany. There were cases in German legal system. Now the case is waiting for constitutional court, where Germany was sued because it provided those things to US, and US killed someone in Pakistan. So there is a very complicated structure, but this is a real risk. So we have this the thing I asked yesterday also to Margot about the proxy forum shopping for what is our partner or other states are doing, we can also be held responsible, and we have to remember that we have much higher human rights standards in EU and Europe, and this is why we have to think twice when using some kind of weapon. So my conclusion is that drones are less legally and ethically challenging than autonomous weapons. We'll see that in articles probably. The use of that kind of weapons heavily impacted certain notions of law, like self-defense or the definition of armed conflict. We in EU, we don't have any specific targeted legal or policy approaches to armed drones, even if we are developing one. And this legal review that I mentioned at the beginning is something that is actually pretty thorny issue, because this is a very long old obligation in international law, and we are still, oh, this is 20 minutes. We are still not doing that. So thank you, and that's all from me. Yeah.